It's a sad fact that creditors can, in fact, garnish wages. Now, a lot of things need to happen first. The creditor must first have a judgment against someone before they can garnish wages. But before they get that judgment, they have to first win in court. Before they win in court, they need to serve you with papers. And before they serve you with papers, you need to default on the debt. So, generally speaking, a creditor can't garnish your wages unless they've taken all of these steps. There is one exception, and that exception is federally guaranteed student loans. Federal student loan law is one of the very few cases in America that have no statute of limitations. The requirement that you need a judgment before you can garnish on a federally guaranteed student loan also does not exist. This means that if you don't pay a federally guaranteed student loan, the Department of Education simply has to write a letter to your employer that says it's time to start garnishing your wages. Now, this is only for student loans. With credit cards, auto loans, home loans, and with every other kind of debt, a creditor needs a judgment before he can garnish your wages. But even if a creditor does have a judgment, there are many exemptions to garnishment in the state of Florida. My favorite exemption from garnishment is the head of household exemption. What it says is that if someone provides more than half of the support for a child or other dependent, that person is exempt from garnishment whether or not that person owes the money. Furthermore, Social Security, pensions, and veterans benefits are all exempt from garnishment. The best way to find out if you're exempt from garnishment is to call a lawyer and find out what your rights are. If you have any questions about garnishment, about judgments, or anything having to do with credit cards or debt, give us a call or drop us a line.